The Platters were formed in 1953. The following year, they recorded the iconic song Only You, which became a massive hit in 1955, one of the first big African American rock and roll successes. Their next single, The Great Pretender, took them to the very top tier of American artists. In the 1950s and 1960s, they were rarely out of the charts. In the following decades, they continued to tour. The lineup evolved, and eventually there were big legal battles between rival groups, each claiming to be the true successors of those original Platters. In this case, the applicant, a music promoter, wanted to bring one of those Platters groups to tour Australia. Getting permission was a three-stage process. First, he had to sponsor their entry into Australia. Then they had to be given visas to enter Australia. And then third, on entry into Australia, they had to obtain entry permits. Each of these was a separate, though related, administrative decision. For obvious reasons, though, there was a departmental policy that once the sponsorship was approved, everything else followed more or less automatically. In this case, the sponsorship application was denied after the local industry representatives objected on the basis that, first, the same promoter had recently brought into Australia another group claiming to be the Platters, and second, that these tours were denying opportunities to local artists. The decision was appealed, but the relief that was asked for was not just overturning the sponsorship decision, but also providing the visa and entry permit, because they all went together. The court found that even though there was a very well understood practice of considering all three together, they were in fact three different discretionary decisions. And the existence of the policy to deal with them all together couldn't replace that discretion. Justice Shepherd wrote the leading decision, but Justice Burchett, agreeing with him, said, "Neither a process nor a true guideline can lawfully be permitted to assume the status of a provision of the statute. The right and duty of the minister to give consideration to an application may not be supplanted, though they may be lawfully assisted by the principles and practices laid down in a document of that kind." From this case, we learn that if the Parliament gives a decision maker a discretion, they must use that discretion and not just blindly follow informal rules and guidelines.